Welcome to a new episode of the Southeast Asia IPR SME Helpdesk video podcast. My name is Valentina Salmoiraghi. I'm the IP business advisor of the IPR desk. Today we're going to discuss IP enforcement in Indonesia. And on behalf of the Southeast Asia IPR SME Helpdesk, I would like to welcome our IP expert, Mr. Somboon Earterasarun, Director of Tilleke Gibbins in Jakarta. Thank you, Somboon, for joining us today.
Glad to be here.
So, to begin with, I would like to ask you a first question. How does Indonesia IP legal framework compare to the international standards?
By the end of 2016, we are going to have new patent laws, new trademark law that will be shaping the new IP landscape for Indonesia. So I think this is something that would be able to bring up Indonesia from the stage where they are pretty much lag behind the international standard, especially when we're talking about enforcement. But with the new upcoming legislations, I think that it will put Indonesia in a better landscape in terms of protection of IP rights.
That's very positive. And in terms of enforcement, so which are the main avenues available for IPR enforcement in Indonesia for EU SMEs?
Okay, in general, you can do either criminal sanctions or criminal proceedings or civil proceedings, but among the criminal proceedings, obviously, the first thing that you have to have is the investigations, and you have to have evidence of that infringement act. So to have that, you have two possible routes. The first route is that you contact to the Trademark Office or Patent Office in Indonesia, which is called DGIP, Directorate General of Intellectual Property Rights. They have the special investigation unit where you can report the complaint to them, and then they would take care of the evidence collecting part, and then they would submit the evidence that they collected through to the police. So that will be the first step that you can do. Or based on your preference, if you want to move ahead to contact to the local police directly, that's also an option. So you can bypass the DJP, and it would then be the police who will be able to have the job to collect all the evidence. But with possibilities that if you want to expedite the enforcement proceedings, obviously the European SMEs can think about having and hiring the private investigator to do the evidence collection part, and then that will speed it up things. So that's on the criminal proceedings. For civil proceedings, obviously as the IP right owners, you can file the court actions to the Court of Commerce in Indonesia. In Indonesia, we do not have a specialized intellectual property court just yet. So every IP cases have to be heard at the Court of Commerce. So at the Court of Commerce, you can ask the court for the court orders to ask the infringer to stop the infringing act, to destroy all the infringing products, and also to get some damages. But in Indonesia, damages will not be as high comparing to European Union, of course, because Indonesia is a strict civil law country, so you need to prove based on the actual damages, and obviously it sometimes be very hard, and there is no punitive damages concepts in these countries.
Thank you. If we focus a bit more on the criminal enforcement, so based on your experience, when the criminal enforcement proved to be more effective for your clients?
Yeah. I think there are two things that you have to consider before you are going to taking the criminal actions in Indonesia. First, you need to have the local language into that, because if, for example, you would like to put somebody into the jails, and then you have to prove that there has been a damage on that on your business, then you have to prove that you have business in Indonesia. Your trademark is using, your patent has been used in Indonesia, stuff like that. And you would not be able to prove the use if you don't have a valid agreement with the local partners, and that agreement has to have the Indonesian Bahasa into that. So that's the first things about the local language. The second things, you need to own IP rights. If you don't have any IP right registered in Indonesia, you will not be able to entitle to any criminal proceedings. So the European trademark, for example, the EUTM that you have registered in European Union, you will not be able to enforce it here in Indonesia without having the local Indonesian trademark registration, for example. So these are two things that you have to consider before you are going to take criminal actions in Indonesia.
Now, do you think that the criminal enforcement is a viable option for SMEs so far?
Yes, it's still a possible way, but obviously we know that Indonesia is still having some problems in terms of bureaucracy, and that's something that before you are going to do that, you need to consult with the local advisor, and then a strategy has to be well crafted before you are going to reach out to the police.
Yes. Okay, so this is quite comprehensive in terms of criminal enforcement. And if we focus our last question then on your experience on civil enforcement, and which are the main information that you would like to share with our European SMEs?
Sure. Before that, let me tell you that in general, like in many Southeast Asian countries, people usually would prefer to go on criminal actions as opposed to civil actions in Indonesia too, simply because the damages are very small, and that will not be having a deterrent effect against the infringers. So civil litigation in Indonesia are, by its nature, very, very rare. But there are some of the cases, and I would say that some of the cases that have been successful in terms of civil litigations, the aim would not be to get the compensations or damages from the infringers, but the aim would be to stop that infringers from producing, infringing, or counterfeiting goods. That's more of that aim.
But is it possible to combine the civil enforcement and criminal enforcement, or companies need to choose and then will choose a civil enforcement if the criminal is not available?
Okay.
Or not possible?
In each of the case, the clients or the European SMEs would have a choices to go on either criminal actions, civil actions, or both. But to go on both ways, usually it will not be preferable simply because of the cost issues, because each of the proceeding will have to be on its own, and a different set of evidence and hearings and proceedings will be done, and that's why usually people would prefer more onto the criminal actions simply because of that.
Okay, very clear. So with this, we shall wrap up our interview today, and thank you very much, Somboon, for sharing your thoughts and also this valuable advice to us. And so
thank you very much for inviting me. Yeah.
And this video was brought to you by the Southeast Asia IPR SME Helpdesk. As a project co-funded by the European Union, we invite you to visit also our website www.ipr-hub.eu, where many interactive learning tools related to cross-cutting and industry-specific IP matters are available for you. They're free of charge for European SMEs looking to doing business in the Asian region. See you soon in another video. Goodbye.